The tribunal wondered why ODM had not repeated the nominations in Taveta Sub County as it had earlier announced and scheduled. During the nominations that had taken place on the 18th of April, it says there was no voting in Chala, Mahoho and Jipe, and the results announced were thus null and void.
The failure to conduct polls in the agreed polling stations amounts to a substantial non-compliance with Kenya's electoral laws as well as the party's constitution, and that this non-compliance affected the result of the final election.
The tribunal claims that ODM and its officials were either negligent or deliberately chose not to follow the law. The party has now been ordered to conduct fresh nominations in the 5 polling stations in Taveta Sub County, and it has 72 hours to do so. Worse still, it has been slapped with the Mruttu's legal fees.
Political parties not only enjoy a constitutional status but also get funds from the public purse and their members. They owe it to their members to invest in proper systems and employ competent personnel who can conduct primaries efficiently and fairly while allowing adequate time for the party to resolve any disputes arising from the process.
Mwadeghu, however, has disputed the orders and says he will appeal. He claims that the tribunal did not take into account his submissions, that voting had indeed taken place in the 5 polling stations, and that there were even MCAs who had been nominated that day in those areas and had been given provisional certificates.
I have a lot of respect for my party. I will not move out of my party, remain my party. I'm an ODM chief whip in parliament, so I'll not move, but I'll not participate in the Chala, Mahoho, because nobody else complained other than one person. The rest have their certificates and some of them were here with me. So what is all this?
Meanwhile, the Dispute Resolution Tribunal has upheld the decision by ODM to award Homa Bay Governor Cyprian Awiti a direct nomination to fight for his seat in the August polls. The case had been filed by one of the aspirants, Sam Wakiaga, who had been displeased by the party's actions.
We find no justification in law to interfere with the decision to award an automatic nomination of the first respondent. We have said this in the past, that the tribunal will not interfere with the internal mechanisms and operations of the party where the same is conducted pursuant to the party's governing rules and regulations.
And in the High Court, the appeals of those who are not happy with the rulings of the political party's Dispute Resolution Tribunal have started coming in. Karoli Omondi is among the first one to file one and is appearing before Lady Justice Njuguna Mwihaki. He is not happy with the decision by the tribunal ordering ODM to repeat nominations in 7 polling stations in Suba South. He claims that these are strongholds of his competitor, ODM chairman John Mruttu, and therefore will not be fair to him. The hearing of the case continues. Going by the rulings of the tribunal, it appears the party would have fared better had it conducted its primaries in a more organized manner, or if it would have followed to the letter the recommendations of its internal dispute resolution tribunal. Andrew Ochieng, NTV.